are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. Sitting with me on the panel for the cases today are Justice Eric Neyman and Justice Jeffrey Kinder. We will be hearing 5 cases in total today. The first of our cases will, as you can see, is being heard on Zoom. We will return to the John Adams Courthouse following the conclusion of the argument in this first case for the remaining 4 cases. The first case on the list for hearing is case number 2021 P497, Commonwealth versus Aaron M. Christopher. Attorney Kelly, this is your appeal. You may begin.
Okay. Thank you, Your Honor. May it please the court, my name is Kathleen Kelly and I represent the appellant Aaron Christopher. The first issue that I wanted to discuss was the fact that the morning of the defendant's trial, the state for the first time, or the Commonwealth for the first time, disclosed that they were planning to admit an admission that the defendant had apparently or allegedly made in a text message. The fact was that at this late disclosure gave the defendant no opportunity to challenge, rebut, or investigate this alleged admission, and that the late disclosure, much like in the case Commonwealth versus Greed, violated the defendant's right to present a defense, and he did not have time to process the information when it was disclosed the day of his trial. And I believe the other issue was this was an alleged written text message from the defendant's cell phone to the complainant's cell phone. The police had the defendant's cell phone in their custody for almost 2 years, and it was only given back to him a week before trial.
Attorney Kelly, let me interrupt you. This is Justice Neyman. Was there any objection by the defendant at trial on the basis of late disclosure?
I believe, Your Honor, that he objected on the grounds of hearsay. I don't believe that he objected on late disclosure.
Okay, so our standard of review then is substantial risk of a miscarriage of justice if there was error. Is that correct?
It depends on where the error was, Your Honor. If the error is on the late disclosure, that would be correct. If the error is on a hearsay basis, as I argued, it was a violation of the best evidence rule to admit oral testimony about a written communications. I think he did. The hearsay objection would have that under an abuse of discretion.
Why is that? It seems to me that if you're arguing the failure to comply with the best evidence rule at trial, shouldn't there have been an objection on the basis of the best evidence rule itself and not just a blanket hearsay objection in order to properly preserve the issue?
Yeah, I think that if you look at the footnote 10 in Saylor, they basically said it was a violation of hearsay to put in oral testimony about a written electronic communication.
That may be, but Justice Nyman's question is on preservation. If you want to make that objection, you cast it in terms of best evidence. A hearsay objection does not raise the best evidence concern.
I think in that case, then it would be substantial miscarriage of justice standard if it was on any other grounds other than hearsay, which is what he objected to. Although, like I'd say, I think that Saylor is suggesting that it didn't fit within the best evidence, so therefore it would have been hearsay. But either way, I think it was if counsel didn't properly preserve it by not objecting to the grounds of the late disclosure, then yes, the standard would be a substantial miscarriage of justice rather than an abuse of discretion. But I think one of the problems here, also as far as the best evidence rule, was even if the prosecution is correct that you could put on oral testimony, if the written communication was destroyed, there was no foundation or testimony to show that here. The complainant never testified to why she didn't have the text message, whether it had been deleted.
Once again, was there an objection on foundation grounds?
No, there was not.
And in the case of foundation particularly, one of the benefits of objection is to alert the judge and the offering party to the concern so that they can supply the necessary foundation. In order to share your concern about the lack of a foundation, it seems to me we would have to be persuaded that that they would have been unable to establish a foundation had they been asked to do so.
Well, I think that the fact is that it's there was differing text messages, and the Commonwealth argued that the defense was late on disclosure and authenticity, and then turned around and tried to present this on the same grounds. So defense counsel did fall short for only objecting on the grounds of hearsay. However, because this was an admission, I think that there was a substantial risk of a miscarriage of justice.
Well, it's an admission. There's no hearsay, right?
It is, well, it's an oral, it was supposedly a written admission, not an oral admission. So you're trying to put in oral testimony without showing what happened to the actual written text. There was no showing or no testimony from the complainant whatsoever on why the prosecution did not have a copy of the written text. And the police had the defendant's phone in their custody for 2 years that supposedly had this alleged written admission on it. They had the complainant's phone, but there was no foundation set under Casio, if I'm pronouncing that incorrectly, I apologize, that you have to show a sufficient excuse for non-production. And there was no testimony or no evidence whatsoever about whether the text was deleted, lost, why it couldn't be retrieved. And the defense, on the other hand, had no opportunity to try to subpoena these records or show that this text or contest it in any way.
The defense had every opportunity at trial to challenge the adequacy of the foundation, but did not.
That is correct. So it would be a
and we have nothing but speculation to rest on in trying to guess at the reasons why it was destroyed, why it wasn't available. We might have more about that if there had been an objection and the Commonwealth had been put to the test.
Yes, Your Honor, but I still think that regardless of whether he objected on this correct basis, for admission to be told to the defense the morning the trial started, clearly the defense had no opportunity to challenge or rebut the evidence.
Well, so it sounds as though what you're resting on then is principally late disclosure and prejudice resulting from the inability to adequately meet the evidence because of the timing when it was disclosed.
That's correct. With a secondary basis being on the best evidence, there's no showing or foundation that it was the Commonwealth has to show the foundation of why they could have sufficient excuse for not producing it. Since I only have a few minutes left, I did want to briefly discuss the other issue of the trial court asking the lead detective on the case her opinion of the complainant's genuineness of her emotional reaction. I believe that impermissibly vouched and bolstered the credibility of the complainant. And it was the trial court that actually asked this opinion of this police officer witness. And because this was a bench trial, it makes the error even more egregious, because he was the one wanting to know her opinion, which I believe was improper vouching, and that there was a substantial risk of a miscarriage of justice for him asking the opinion of this officer.
Attorney Kelly, I have two questions on this issue, if I may. The first is, I believe the defendant testified to the effect that the victim in this case was an actress and that she was acting here. She was feigning being drunk and she was feigning crying or something to that effect. That was either pursuant to the defendant's testimony and or pursuant to cross-examination. The Commonwealth argues that that opened the door to this question, to explore this area. Why is the Commonwealth incorrect?
I believe the Commonwealth is incorrect because the defense has the right to challenge the credibility of the witness, just as the Commonwealth had the right to challenge the credibility of Mr. Christopher. However, asking a police officer or another witness to comment on the credibility, basically, of the complainant.
Well, but this was not a comment on the credit to assess the credibility of the witness. This was the authenticity of the emotional state that she displayed. Those are two different things.
That is correct, Your Honor, but I believe this case is like Commonwealth versus Trowbridge and Commonwealth versus Montenegro, where the court is saying while it fell short of an opinion, it came dangerously close to endorsing the victim's credibility. And I think in this case, asking questions of her, clearly, asking the officer about her demeanor was fine. Asking the officer her opinion of the genuineness and whether she was faking came dangerously close to vouching, just like in Commonwealth versus Trowbridge. And it was the reason that the trial court asked this witness's opinion to begin with was buried on credibility, which he should have based it on his own credibility determinations of Mr. Aaron's testimony and
Trowbridge was a direct comment on the expert's belief of the complainant's allegations. That's not what this was. This was the authenticity of her emotional state, whether her presentation as being distraught was genuine or contrived. That's very different from Trowbridge. Don't you recognize that?
I think, though, what Trowbridge is saying is that there can still be a violation even if the evidence is short of commenting on their credibility. And I believe in Trowbridge, they said that testimony did fall short of an opinion of the credibility, but it was endorsing it. It was
comment on the substance of the allegations, not on the recipient observations of her emotional state.
It is not directly on point, Your Honor, but I think it was dangerously close enough to endorsing her credibility by commenting on that. I still think it was improper of the judge to ask the police officer, particularly when he's saying, after your years and years of experience in investigating sexual assault, cases, did you feel her emotions were genuine? I think it falls close enough to being weighing on credibility
Well, to the extent that you
violated.
share your concern that it was close to the line if it didn't cross it, how do we evaluate the judge's capacity to instruct himself correctly about that appropriate boundary line?
I think the fact that it wasn't the Commonwealth that did this, but the judge himself that elicited the opinion and brought in the fact of her experience in dealing with sexual abuse, that we can't trust that. You know, it wasn't the Commonwealth that did this. It was him directly eliciting the opinion and asking it based on her years of experience in talking to sexual abuse victims. So the fact that he himself elicited it, clearly he wanted to know her opinion. And so I think that clearly shows he was looking for it in making a determination of credibility.
All right. I see you've reached the end of your time. Thank you for your argument.
Thank you, Your Honor.
For the Commonwealth?
Thank you. May it please the court, Mackenzie Slyman on behalf of the Commonwealth, asking this court to affirm the defendant's conviction in this case. Turning first to the first issue briefed by the parties as to the testimony of the text message that the victim received in this case from the defendant. I think it's incorrect to classify this as a late disclosure. The Commonwealth only became aware of this text message because the defendant provided the Commonwealth the night before trial with screenshots of his own text messages that he was going to be seeking to admit as evidence to the court. Based off of receiving those text messages on the morning of trial, the prosecutor spoke with the victim, asking her if these text messages entirely covered any conversations they had. And it's only at that time that the Commonwealth was made aware of the text message at issue that the victim testified to. Immediately upon becoming aware of it, the Commonwealth memorialized this in writing and provided it to the defendant. So I think a late disclosure is the incorrect way to classify this. Further, this is not evidence that the Commonwealth would have been required to turn over or I guess seek out prior to becoming aware of it. This is not Rule 14 evidence. Commonwealth versus BL is very clear that independent witnesses are not part of the prosecution team and therefore are not subjected to the requirements of mandatory discovery that Rule 14 provides. So the Commonwealth didn't have any requirement to seek out this testimony or these messages from the victim. And once the Commonwealth was made aware of it by the defendant's own acts of seeking to, at the final hour, bring forward these text messages that he wanted to have brought into evidence, is the only reason that the Commonwealth became aware of the text messages and turned them over as soon as they received them. To touch briefly on the best evidence rule here that has come up, I also disagree that the Commonwealth had to provide any basis for why it was not providing the written form of the text message. The Mass Guide to Evidence, Section 1007, is clear that in situations where the statement is made by a party opponent here, that the government is not required to provide an exception for not providing that in writing. That oral testimony is sufficient so long as authenticity has been established. And here, as the court has already pointed out, the only objection made at trial was to the hearsay nature of the text message testimony. So for those reasons, the text message testimony was properly submitted to the court, and the foundation was adequately laid. If the court has no questions about that issue, I'll turn to the second as to the testimony.
Yes, let me ask you about the second issue, the vouching issue. So as I understand it, the judge asked the detective whether or not, based on her years of experience, specifically in sexual assault areas, did the victim appear to be acting or faking her emotional state? Is that correct?
Yes, Your Honor.
So if the answer to that is no, she did not appear to be faking, then presumably the inference to draw is that the victim was telling the truth, correct?
I would disagree with that, Your Honor. I think there's a distinction to be made here between testimony regarding any witness's belief of the statements being made by a witness or a victim as to the truthfulness of the substantive things that they're telling the witness about what happened. Here, the Sergeant Carey was only opining as to whether or not she believed that the victim's emotional state was genuine in that moment. And I think that those are separate and crucially separate distinctions to be made here. She was not opining.
I'm sorry to interrupt you, but what case stands for the proposition that a witness can comment on another witness's, strike that. What case stands for the proposition that a witness can comment on their view of the truthfulness or accuracy of another witness's emotional state?
I think I would point the court to Commonwealth versus Canty, which states that there's no, I suppose this is more roundabout, but that so long as the witness is not touching on an opinion on an ultimate issue, that they're allowed to offer any opinion to anything in the case, so long as it's, again, not as to the guilt or innocence.
Well, we have a lot. I'm sorry, go ahead.
I was gonna say there's a separate concern about a basis of knowledge, right? I mean, how can we purport to provide valid testimony about the inner workings of someone else's mental process?
I think that's an issue or a concern that would apply to any testimony that anyone's providing as to how anyone's behaving in the moment.
Well, whether it's authentic or contrived, right?
Correct. And I think there's an implicit inference when any victim, any witness, and I don't mean to, and I think this goes beyond it being a police witness. If any witness is testifying to the emotional state of someone that they're encountering, that I think there's an inference there that they truly believe that that's how the person is feeling or behaving in the moment.
No, but I mean, that's the point, isn't it? You can certainly relate your percipient observations of their condition, their facial expression, their apparent emotional state. Going behind that and offering an opinion about whether that is genuine or contrived steps inside the other person's head. What is the basis for someone to offer that testimony?
I think turning to this case specifically here, the defendant opened the door to this line of testimony when he asked the victim in her cross-examination and grilled her essentially there about her training as an actress, that she was trained in portraying emotions, that she learned how to cry on demand. I think that line of testimony opened the door for the Commonwealth for the Sergeant Carey to opine to her belief of the validity of the victim's emotional state.
So go back to my question. Tell me any case where we've ever said a witness can opine on the validity of another person's emotional state or demeanor. It seems to me that our cases allow a witness to describe in detail what they saw and what they observed, and it's for the jury to make the remaining determinations. Show me any case that says that a witness can comment on the accuracy, i.e. the truthfulness, but let's call it accuracy, of another witness's emotional state. I don't know of one.
Sure, Your Honor. I don't have a citation for the court. I'm happy to look after argument today and provide us any citations in a 16L letter. But again, I think it's implicit in by virtue of providing the testimony at all, that a witness believes that the person that they're testifying to, the emotional state of that person, is legitimate. If you're testifying to how is someone acting, what's their demeanor.
If you're saying someone's demeanor and the way they appear is legitimate and real, how is that different than vouching? You are basically saying that person wasn't faking, which is another way of saying they're credible.
I would disagree,
or
Your
they're
Honor.
credible as to that sub-issue.
I would disagree, Your Honor, because I think speaking to a witness's belief that about the emotional state of another person, it doesn't necessarily tie to the factual statements that are being made that are accompanying that interaction. It can be, that this emotional state was valid for any reason. It's not that it was tied to the factual statements that were being made by the victim or the witness.
Wasn't the emotional state relevant for the purpose of suggesting that her allegations, in fact, related something that had just happened to her and provoked the trauma that she was displaying?
Right. Why else are they relevant, in other words?
Yes, sir. I think here it's relevant to combat the attack that had been made on the victim's credibility through that line of questioning.
Why was testimony about her emotional state relevant to begin with?
I'm sorry, from Sergeant Carey or
Anybody. I mean, the entire relevance of her emotional state was to lend credence to her allegations of having just been assaulted, wasn't it? Wasn't that the whole point?
I would disagree with that, Your Honor. This line of questioning again was only
to what relevant proposition was her emotional state otherwise probative?
I think it goes to the credibility of the victim, not specific to that instance, but as to her testimony in the courtroom. I mean,
the fact that she was showing signs of trauma meant that she was generally credible, not in particular to the allegations that one might infer had provoked the trauma.
I suppose, I think it goes more generally to her credibility. And I think, and not as to specifically this instance, but I think the cross-examination of the victim by the defendant, where he brought up her bachelor's degree in acting, that she was trained in manipulating or portraying her emotions, that she was trained on crying on demand, speaks to overall her credibility. And I think when that door gets open, it's fair to then ask someone who saw her in that moment if they believe that her emotional state was invalid.
Let me ask, I don't want to belabor the point, but let me ask it a slightly different way. Let's assume at trial a victim is vigorously cross-examined, challenging her credibility. And the police officer who happens to be an advisory witness is later called to the stand by the prosecution. Would it be appropriate, in your view, to ask that advisory witness whether or not the victim appeared to be testifying truthfully?
Testifying truthfully during the trial, Your Honor, or I don't think it would be appropriate for a witness to speak on
trial or prior to trial.
I don't think it would be appropriate to be testifying as to a witness's view of how an individual is testifying during a trial. I think that would muddy the waters.
Challenge doesn't open the door for vouching, right?
I'm sorry, I didn't catch that.
A challenge to the credibility of a witness does not open the door to vouching, in other words.
I believe so, Your Honor. I may be misunderstanding your question, but I really think here that the facts of this case hinge especially, on the line of questioning that was put before the victim, that this was merely done in response to that door that had been open.
We're nearing the end of your time, and I do want to ask you a question about the exclusion of the evidence about an alleged prior consensual encounter between the victim and the defendant, and on the basis of the rape shield statute.
Yes, Your Honor. So turning to that issue, the court properly excluded this evidence. There was an in-camera hearing held because the defendant was claiming that there had been a prior consensual sexual encounter. I think the calculus was done here correctly, that if this had any probative value, which the Commonwealth does not concede that it does, that it was outweighed by the prejudicial effect that would be suffered by the victim here. I think it's really important to look at the substance of what the defendant testified to in that in-camera hearing. He testified that hugging and kissing had happened on this prior occasion, but he doesn't describe any nature of the kissing. Where it was happening. Were they kissing on the mouth? Was it kisses on the cheek? It doesn't dictate the nature of how that relationship was, or how those relations were happening that night. And I think it's important too that the defendant explicitly said that this was not a sexual encounter. His testimony on transcript volume 2, page 11, any touching wasn't of a sexual nature. I wasn't touching any parts, just kissing and hugging. And further too, during his in-camera hearing, the defendant by his own admission says that she was acting drunk, but that he didn't believe that she was actually under the influence or intoxicated. So I think all of that together in separate ways lessens any probative value that there would be here to his testimony. It's unclear from his testimony, number one, that this was a prior sexual sexual interaction. By his own statements, he didn't perceive it to be as of that nature, but especially where the defendant, by his own testimony, raises a question as to the intoxication of the victim on this prior alleged incident, where he says that she was acting drunk. He just didn't believe that she was acting drunk, which in fact he later testifies to being his same belief on the night of the incident that he was on trial for, negates any possibility that this was a prior consensual encounter that would even put this in the realm of being admitted. And I think Commonwealth versus Fionda is the best case for that, prior risque conversations or kissing, even if admitted to by the victim, is not probative of whether there was a consensual encounter on a subsequent date. As I said here, where by the defendant's own raising of the question of her intoxication, it's not clear at all that this was a consensual encounter, if it even did happen beforehand. But any probative value that the court, even if it were to prescribe it, a probative value, is incredibly minimal here, given the entirety of the defendant's testimony, which lacks any specificity about the hugging and kissing that may have occurred, and by his own admission was not sexual in nature. So for those reasons, the court acted correctly and properly in excluding that testimony.
All right. I see that your time has also reached its end. Thank you. Thank you both. The case is submitted. We will conclude this video hearing and then resume the session in courtroom 4.
Thank you.
Thank you.